Thank you. Each side will have 15 minutes. You'll keep your own time. And Mr. Anderson, when you're ready.
Thank you, Your Honors. May it please the Court, Craig Anderson on behalf of Officers Smith and Huntsman. This is a Section 1983 excessive force case where the District Court failed to properly apply the qualified immunity analysis. At its core, there's two main issues on this appeal. The first one is whether the District Court acted appropriately when a sua sponte found that there was not probable cause for the mental health hold on Mr. Scott. And the second primary issue is whether the force used by the officers...
Can you lean in a little bit to the microphones? I'm having some difficulty hearing you.
Apologize, I never hear that, so I was actually standing back. So
Thank you.
Yeah. So starting with the probable cause issue, the District Court, without briefing or the benefit of counsel argument, just made the decision that there was not probable cause to perform the mental health hold on Mr. Scott. As this court is well aware, the issue of probable cause is an issue of law when the facts are not disputed. Here, the facts in this case clearly justified at least the detention of Mr. Scott to evaluate the severity of his mental health crisis. What the officers knew was that he had made a call to 911. He had reported that 3 men were trying to break into his apartment, that one of them had a saw and was trying to harm him. The officers learned that those facts were probably not accurate upon arrival. When the officers knocked on the door, Mr. Scott told them to break the door down. He told them to come in. The officers did not. They returned back to the base of the stairwell, called their sergeant, who said, you need to go make sure this gentleman's okay. When the officers returned, Mr. Scott did exit the apartment, but he was possessing 2 weapons. He was not aggressive. He was not violent towards the officers, but he was clearly in a state of distress possessing these weapons. When he placed himself against the wall, he told the officers, I have paranoid schizophrenia. He told them that he was in mental distress, and he said, please put me in the car, because he had been the recipient of legal 2000s, which is the term in Nevada for a mental health hold, on prior occasions. Because he had possessed 2 weapons, which he had voluntarily surrendered to the officers, there was a justifiable concern to at least pat him down to make sure there were no more weapons in play, because the officers would have never turned him over to medical personnel or even conducted the investigation without first assuring that the scene was safe and that it was static. The District Court ignored these facts and found that no reasonable officer could find that he was a danger to himself or others. In other words, the District Court was implying the officers should have just left.
Isn't this a disputed fact that whether or not he was dangerous? I mean, your briefing, your argument today suggests that there is a dispute about whether or not Mr. Scott is dangerous, and we have to resolve that in favor of the plaintiff. Is that correct?
No. The reason that it's not, it could be a disputed fact. The issue, though, is whether there was probable cause, which we know is a very low bar that is not a disputed, that can be decided as a matter of law if the facts are not disputed. And based upon these facts, any reasonable officer would have concluded that further investigation and detention was necessary to determine whether Mr. Scott was a danger to himself or others. Because under the District Court's theory, if they had just left and then he had either harmed himself or someone else, then there would be a lawsuit with them saying you were just barely there. You were there. You could have taken him into custody and got him the mental health he needed, but you left. And so it is not a disputed fact because the facts that give rise to the probable cause are not disputed. And I would point out again that there was no briefing on this issue with the District Court. And under Rule 56F, if the District Court felt that there was not probable cause, because it was never raised by the plaintiff, they never argued there was not probable cause to detain Mr. Scott. Their own expert agreed there was probable cause to detain Mr. Scott. Their complaint says that he, at paragraph 116, that he was suffering from a severe mental episode. In their opposition to motion for summary judgment, they argued they had a legal basis to take him into custody. And so everyone agreed that there was probable cause to take him into custody until...
Is anyone suggesting that they should have just left? I mean, instead they take him down, they tackle him. What role do they call the sergeant? Why didn't they call the mental health support? They were able to call the sergeant. Why weren't they able to call mental health support instead of taking him down?
Okay, well, I think initially when they got him outside, the first step that any reasonable police officer would do would be to make sure the scene is safe. So they wanted to pat him down, make sure there were no other weapons because he'd already had 2 weapons in his possession, and then interview him and investigate as to the severity of his mental illness, his intentions, because he had referenced that people were trying to kill him. And
so at that point, he's a victim.
at that point, he is definitely a victim. But once they realize those people are not there, that he is hallucinating, that he is seeing things that are not present, they then have an obligation to him under the community caretaking function to get him the mental health that he needs. And so he is always a victim. I mean, there are some minor crimes potentially at issue here, but the officers were not interested in investigating those, and I concede that. Their interest was solely in getting him the mental health help that he needed.
So he's not being accused of committing a crime. The only reason there's probable cause potentially is he's able to harm himself or he's able to harm others.
Correct.
But he's been compliant, so I don't understand the need to tackle him.
He's been compliant, but it does become concerning, and I'm not trying to overstate the case here, but it does become concerning when he were not allowed the pat down. And still, the officers stand back. You know, they're not armed, they're not threatening him. I mean, they're not displaying weapons, and they're trying to address him and have a conversation. Then he goes and unzips his zipper and begins reaching towards his jacket, and that's when they simply step in and grab his arms. And as you can tell from the video, there's not an immediate action to take him to the ground. They are attempting to pat him down from a standing position, but at that point, he does begin to show some minor resistance. And that's where this case becomes extremely similar and almost on all fours to the Drummond case, where the gentleman was exhibiting similar type behavior, not necessarily a danger to himself and others in the parking lot. Only Drummond was known not to be armed. He was only thought to be potentially a danger to himself. And in that case, the officers immediately knocked him to the ground and then effectuated handcuffing, which the Ninth Circuit found was reasonable. They were not concerned about the pre-handcuffing force on Drummond. And so this case, with respect to the detention and the taking him to the ground, and unfortunately we have the video in this case, which shows this was certainly not a violent takedown, that the officers each guided him down with one arm. He was placed on his back. They were talking, saying, watch his head. There were the rocks. They were monitoring him consistently. And so under Drummond, if an officer was familiar with that case, they would believe that this action was reasonable. Because
do you agree that Drummond recognized that the use of body weight force creates a risk of asphyxiation?
Correct. I mean, Drummond clearly stands for the proposition that once a suspect is prone, restrained, and no longer a threat, that the continued, and the word in Drummond is prolonged, use of body weight can cause the risk of asphyxiation. I think that's the established rule. But Drummond applies to post-handcuffing actions of the officers. It does not apply to pre-handcuffing force of using body weight to effectuate handcuffing. And every court that has interpreted Drummond in this circuit, and I don't think there's any other published ones, but unpublished in the district courts, have made it clear that Drummond applies to post-handcuffing force.
And here, wasn't Mr. Scott essentially, wasn't the equivalent of being handcuffed? His hands were behind his back, they were restrained. What's the meaningful difference?
So so at what point are we talking? So when he goes down, there is a struggle for roughly 1 minute and 30 seconds where the officers are struggling with him. He's on his back for a large portion of that time. They eventually roll him over. And then once he's handcuffed, the officer remains on him for 8 seconds. And so he got off of him within 8 seconds of handcuffing. And so that would be the time period which no court has found that short of a period of time is unreasonable in this type of a situation. Most recently in A&B versus, I think it's City or County of San Diego, a panel of the circuit in a non-published decision found that 30 seconds after a suspect stopped moving and was no longer resisting was not unreasonable. And the shortest period of time that a court has found is the Abston case, which is another unpublished decision, which was 1 minute and 7 seconds, and they found that to potentially be unreasonable or a jury question. But in A and B, the court found that 30 seconds was reasonable. And here at most we have 8 seconds where Officer Huntsman remained on Mr. Scott. But so that force, there's no case that plaintiff has cited to, the district court found, or that I found, that the force used prior to handcuffing was unreasonable. That the officers were not entitled to place him on the ground, use their body weight, control his hands, and handcuff him. What their obligations were under Drummond and its progeny is to get off him as soon as the handcuffing is completed and is safe to do so. And I would argue, even with the probable cause issue, which I do not think is a hard issue to decide, I think that based upon the admissions of the plaintiff and the facts of this case, it was reasonable to attempt to detain him and to investigate the severity of his mental health crisis, that even if there was not probable cause, he did not have a right to resist under Luchtel and Arpin, which say that a suspect can only resist and unlawful detention if the officer is demonstrating bad faith or provocative conduct, which, based upon the video, there's no evidence of that in here. I don't think there's any dispute that everybody was trying to do the right thing. I have 5 minutes, which I'll reserve, or do you have any other questions?
I do have a question,
thank you.
counsel. So can you cite to me any case law where our court, the Ninth Circuit, has reversed a district court's factual findings because the objective evidence blatantly contradicted those findings? Because I believe that's what we need to be able to do here, correct? We need to find that the district court's finding on probable cause, if I'm understanding you correctly, is blatantly contradictory to the facts in the case. So
on the probable cause issue,
Yeah.
Hughes versus Rodriguez, Hughes, Hughes v. Rodriguez. There's also a case Ballou, Ballou, which it's a published decision that the court reversed part because the video blatantly contradicted, and then found other parts of the video to not blatantly contradict. So it was kind of a partial.
So does the video in this situation plainly contradict?